Good afternoon, and welcome to the Wonder at Home webinar with our topic on technology and your privacy in the COVID-19 response. I'm Daisy Jenkins, president of Daisy Jenkins and Associates, a proud alumna of the James E. Rogers College of Law, a member of the University of Arizona Foundation Board of Trustees, and pleased to be the webinar moderator. I'm joined today by Jane Bambauer and Andrew Woods, both professors of law at the College of Law. The COVID-19 pandemic has raised the stakes of current technology law and policy debates. Are we willing to tolerate more surveillance in exchange for better health outcomes? Who should get to make the speech rules for large private platforms? How, if at all, should offline rules apply to our digital worlds? Our panelists for this discussion, with extensive expertise in both law and technology, will discuss these topics and answer participant questions. Today, we'll begin with brief introductory comments by our panelists, followed by an opportunity for the panelists to answer the questions you submitted at registration. Now, don't fret if you didn't submit earlier questions, because throughout the discussion, you'll also be able to submit questions using the Q&A function. I'll review and ask panelists to answer as many questions as time permits. We will then wrap up with any final thoughts from our panelists. Let's now begin with Jane Bambauer, our first panelist, followed by Andrew Woods.
Hi, everyone. So Andrew and I also run the Arizona Tech Law program. And one of the things that winds up coming up over and over again in our research and our teaching is that as technology makes things that were once impossible more possible, it winds up unearthing some hidden assumptions in our policy and our expectations that then need to be examined anew. I think that the COVID-19 crisis and the technological response and adaptation to it is a good example of that. So I'm going to focus a little bit on digital contact tracing and the privacy implications raised by that, and Andrew will touch on some other topics. So we're in an era where we have amazing digital technologies that allow us to passively collect a bunch of information as we go about our day, and then make use of it in some novel way, some secondary unexpected use. That is, of course, what raises tremendous surveillance risks. And privacy, as both a concept and a public debate, is really our opportunity to collectively figure out how to make these trade-offs. So when I look at where we are with contact tracing today, given that we have the best digital technology, especially with respect to wearables and mobile phones in the world, and we have the companies too that sort of designed these systems, I am tremendously disappointed that we have not seen a responsible federal or even coordinated state response that allows us to leverage these technologies to help slow the spread of the epidemic. I think this happened in part because Apple and Google, which are both private companies that have a long history of sort of privacy abuse, or at least distrust among the public, they came out way ahead and developed a system that would allow digital automated contact tracing through Bluetooth technology. And there's some things that are really cool about that system, but the trouble is that it created a backbone for the technology that didn't really have efficacy in terms of public health response at its core. It had privacy and sort of public relations at its core. And as a consequence, we have seen that it's quite hard for public health authorities to make good use of it. And that's one reason that we have not seen either here or in even in other countries really effective use of digital technology to help us with contact tracing. The only thing that makes me feel slightly less frustrated than I otherwise would is that we are also way behind on testing, which is kind of predicate to doing good contact tracing. So I see this as a moment to learn from what has happened and try to improve how we think about and talk about privacy trade-offs, so that the next time we're in a situation where digital technology can both add great value and bring risks, we know how to divide those things and capture the first thing while minimizing the second. It doesn't seem right that we have that we regularly as a society use all sorts of tracing data, all sorts of geolocation and web browsing data in order to help facilitate advertisers sell a bag of Doritos, but we can't use those same technologies to effectively combat the spread of COVID. There are definitely some things that the federal government, state governments, and even the private companies could have done differently to allow radical transparency so that we all know what's going to happen, and so that it builds trust in the system, and so that there's an obvious endpoint and limited purpose for what we use this data for, while also allowing us to actually make use of that data. Andrew, do you want to comment on some of the other things we're going to talk about?
Yeah, sure. So the first thing I guess to note is you're not a Doritos fan?
I like Doritos, but I have my priorities.
Okay. Hi, everybody. My name is Andrew Woods. I'm a professor at the College of Law, where my research focuses on the regulation of technology. And in particular, I think about how rules designed for the physical world apply to the digital world. I want to briefly discuss two ways that COVID interacts with technology and society. The first is that COVID is really aggressively accelerating our transition to the digital world. And the second is that in the process, COVID is revealing some of the limitations to democratic deliberation and policymaking in that digital world. In particular, I want to focus on our rules around free speech. So first, we are digitizing faster than we ever have. By January of 2020, all of us were living part of our lives in real space and part of our lives online. The trend was towards increasing amounts of time spent online. And studies show, of course, that screen time is up with a big shift away from TVs and towards other kinds of digital screens. And COVID just accelerated that shift by quite a lot. I've seen estimates of 10 to 20 years. Examples of this abound: remote work, remote learning, remote shopping, telemedicine, telelaw, just about everything. We all had a foot in the physical world and a foot in the digital world. And then when the physical world became dangerous, many of us who had the means to do so said, let's spend more time online. And of course, the beneficiaries of this have been internet companies whose stocks have soared. That trend was happening already, but COVID forced it to happen much faster. Naturally, as we transition towards that new digital world, there are growing pains. And one of the things that comes up as we adopt new technologies and spend more time in the digital world is squaring old rules, old laws that we had developed for physical space to these new digital domains. We have tended as a country to develop rules around technology slowly and piecemeal. We have a fairly dysfunctional legislature. I don't know if you've noticed. So as a consequence of that, courts have played an outsized role in setting technology policy. Some people think that's very bad, but the one upshot of court-made tech policy is that it's piecemeal. It's one case at a time. That was the world before COVID. COVID has arrived, it forced many of us online in numbers and to an extent not seen before, and it's amplifying some of that regulatory friction. We could talk about lots of different aspects of that challenge. Jane already mentioned some of the privacy concerns that have arisen from the old way of thinking about privacy faced with this new challenge. I want to talk for a minute about speech, okay? So in essence, we're running a massive experiment right now to see how the country debates public policy on the fly when most of us get most of our news and express most of our views on private digital platforms. These platforms are characterized by information overload, that's the kind of information overload too, we are cabined into echo chambers that are rife with fake news, rife with censorship. The platforms often make arbitrary and unreviewable decisions to take down information or to highlight some information, whether it's fake news or not. And all of this is managed by algorithms that are designed to increase our time on the platforms and therefore company profits. It's really a mess. These platforms are where we will spend the months leading up to the 2020 presidential election. Oh, and by the way, they're open to the world, subject to foreign influence operations and subject to hacking campaigns. Now, again, the problem of digital information ecosystems, whether helpful or harmful to democracy, is not brand new, but COVID is making salient just how poorly the old speech rules guide us in this new digital domain. To take just one very prominent example, consider the most important American speech law, really the most important speech law in the world, the First Amendment to our Constitution, which we typically say guarantees a right of free speech. Actually, what the First Amendment does is prohibit the government from suppressing speech. It says, in relevant part, Congress shall make no law abridging the freedom of speech. There's a lot packed into the First Amendment, and I'm leaving aside press and assembly and religion. But for our purposes, I just want to point out that the First Amendment has next to nothing to say about the problems that we're here to discuss today. The First Amendment was written for a different kind of speech problem, with a different kind of speech problem in mind than the one we face today. It was written when speech was really expensive. To be heard, you needed access to a printing press. There were very few prominent voices. There was a shortage of ideas which were considered precious. And the greatest threat to those ideas was thought to be government censorship. And historically, that had been true. And that assumption really did hold true for the bulk of American history. But many of those assumptions are no longer true today. We live in a digital world where there's a cacophony of voices, and the gravest threat is not that you can't speak, but that you won't be heard in the crowd. So if the old speech problem was silence, the new speech problem is noise. Also, the First Amendment sees the greatest threat to speech as government actors. And today, I think many of us worry about private actors, about which the First Amendment says very little. Just chew on that for a minute. Our most important speech law has nothing to say about the gravest threats to free speech in 2020. If Mark Zuckerberg or Vladimir Putin decide they want to influence America's digital information ecosystem, the First Amendment doesn't say anything about their ability to do that. In fact, would stand as a barrier to legislation to attempt to craft a better information ecosystem. So on that grim note, I'll stop, and I look forward to the conversation.
Great. Thank you, Jane and Andrew, for those informative comments. Our participants have submitted some great questions, so let's get right to them. First question, because the internet is inherently international, shall we regard GDPR as binding to all companies on the internet?
So this question is very timely because just a few days ago, there was a very important case decided by the European Court of Justice, Schrems 2. If you didn't call it Schrems 1, but that was also extremely important. But in any case, what the most recent Schrems opinion did was invalidate the U.S. government's attempt to kind of broker a deal such that U.S. companies could bring European data to the U.S. while promising to adhere to this. It was called the Privacy Shield, and the Privacy Shield guaranteed certain types of enforcement against violations. Any company that violates GDPR who subscribes to it. Well, the European Court of Justice decided that because the U.S. engages in so much anti-terrorism and intelligence-directed surveillance, even the Privacy Shield did not sufficiently comply with GDPR. And so each company either has to prevent European data from coming to the US, or they have to use this other mechanism, these standard contract clauses. It's not even clear whether the standard contract clauses will be will be compliant with GDPR, though, given the background context of U.S. Surveillance. So, I think the question rightly anticipates that Europe's privacy law is having an outsized effect. It's not just about Europe. Companies, American or otherwise, that want to do business in Europe will probably have roughly similar protocols in all of their countries, just in order to, reduce their costs. And then maybe even more importantly, though, what they're really exporting even more than the law is mindset, a sort of culture of privacy. And you see that here in the US, where, when I first got my start as a privacy scholar, it was common to think that the US had one approach to privacy and Europe another, and that the US was sort of sectoral and kind of harms-based and sort of more tort-like for the legal audience. That's just not true anymore. You can see echoes of GDPR in California's new Privacy Rights Act or Consumer Privacy Law. And so even though I don't think it's at all clear what Trends 2 means in practical terms, because the opinion leaves a lot of uncertainty in its wake, I think the bigger picture is that, yes, GDPR is changing privacy for the world.
Great, thank you. Here's a question that really covers one of my concerns, since I'm participating in the Black Women's Health Study and providing contact tracing through Mass General. How does contact tracing impact business owners with employees, and does HIPAA still apply when it comes to warning the team?
Okay, so let me back up a little bit to say a little more about contact tracing so that we're all kind of on the same page. The hope with contact tracing apps is that if somebody tested positive and they were participating in a program, a contact tracing app-based program, then either the person themselves, the COVID positive patient themselves, or the public health authority would alert others through the app that if they've been in relevant contact with the person who tested positive. So you can imagine why something like our cell phones would be a great mechanism for this, because we don't have to pay attention to who we're near and for how long. And then later, if we test positive, the digital trails that go back 2 weeks can be exploited to send out a custom crafted notice. So maybe for some people that had pretty trivial contact, they could just be put on notice and say, watch out for symptoms, maybe try to reduce your mobility a little bit. For people who are in significant contact, they could be tested. I already mentioned that with testing shortages, that theory really starts to fall apart, which is why, South Korea, which has had abundant testing given its, in comparison to its case rates, it's able to really exploit contact tracing in a way that we just realistically can't yet. But even if we could, the fact that we have only voluntary programs and that are not particularly well developed, at least not yet, still raises a lot of doubt. So in Arizona, for example, the U of A, actually all of the universities, all 3 universities have been working together with COVID Watch, a nonprofit app, to make use of this Apple Google technology that uses Bluetooth to see which phones are near each other, so that we can do something like digital contact tracing. It's quite limited because of the restrictions in the technology that Apple and Google have insisted on. So it does not use geolocation, for example, and that's going to limit somewhat. It means that even if you know the 2 phones are in close proximity, you can't infer too much from that, because it could be 2 people on opposite sides of a window, or it could, it doesn't give enough context to know whether whether for sure, to have great confidence in whether the contact is meaningful. Nevertheless, I think the U of A is in great shape for doing as much as they can with the technology, and it's in testing right now. If it winds up being both efficacious and safe, and by the way, there are a lot of privacy and ethics sort of parameters going in, then the entire state is likely to offer this app to the entire community. Even if it does, though, I am a little concerned about whether businesses will adopt it if they don't have the right incentives. What would give businesses the right incentives is if there's at least some possibility that by failing to take enough precautions, they could be held liable, or an insurance company would have to pay out some sort of fine, or rather a payment. But at least in the bills that are being considered in the Senate right now, one of the key positions of the GOP leaders is that immunity from lawsuit is a key part of the package that might roll out in the coming weeks. So with legal immunity, I am not sure. It means that employers and retail spaces have to have the right, that they have to be operating on the right reasons, on sort of moral grounds, to make sure that they're using anything that would keep people safe. If they have either moral or legal incentives to use the best precautions, something like the app might be adopted. Or it might not, because I think there's still I have quite serious doubts that the app as designed is actually going to add much value anyways to doing contact tracing. So I think it's still quite an open question about whether employers should or will use something like digital contact tracing, although I definitely think it's still worth exploring right now. On HIPAA, that's not so much of a concern, because I mentioned that the two routes to transmitting information to others was either through the patient themselves or through the public health authority. HIPAA is a funny law. It's not the only law that covers sensitive data, but it's the one that people are most familiar with, and it's actually quite narrow. It's restricted to healthcare providers. Public health authorities who are managing a public health crisis like this one are exempted explicitly from HIPAA's application. And then patients can do whatever they want with the information that they have. So HIPAA is not going to be the main constraint. The practical constraints on these app designers, though, are twofold. First of all, Apple and Google are putting limits on how you can use at least their Bluetooth technology. Not so with other types of apps that don't make use of that technology. One of the limits, by the way, is that you can only is that you can't use geolocation, which of course bleeds into the efficacy problem. The other thing, though, is that anytime an app developer rolls out an app, they'll have some terms of service that at least provide some notice about how they're going to be using the data. And if they violate their own terms of service, the Federal Trade Commission then has grounds for an investigation and a complaint against the company.
Jane, I think we do have quite a few questions.
Sorry.
So, yeah. So we want to get to them. Thank you. Andrew, this is a question that you actually, I think, touched on a moment ago. How does one balance misinformation and freedom of speech, especially when there are public health consequences of the former?
Yeah, so I should have started. I don't know why I'm talking about speech. I'm not a free speech expert. I've just started to get interested in this because if you're interested in the regulation of digital platforms, you get pulled into speech conversations. It's actually, Jane and I had a conversation about speech a long time ago, and that was really clarifying to me that there are so many competing conceptions of what free speech could mean, and it's just a hugely contested topic. The most compelling conception of free speech to me has something to do with, I don't love the marketplace term, but a marketplace of ideas. The idea, it doesn't have to be a true marketplace, but the thought that we all benefit as a democracy when the best ideas can be seen and good, sensible deliberation takes place. So I'm interested in the health of the overall information ecosystem. And I also think any sensible information, system of regulations around information would allow for emergencies and special rules to be adopted in emergencies. And a global pandemic sure seems like a good one. The problem is, of course, compounded, just like everything else, by a lack of leadership at the very top in this country. So, it's sometimes hard to disentangle how much of our problem is due to the digital technologies and how much of our problem is due to a dysfunctional political system. Wouldn't want to overcorrect merely because of the president at the time, but yeah, it's hard, and I don't have an easy answer.
Thank you. Well, this is probably a good follow-on question. As President Trump strips the CDC of control of coronavirus data, how will patient data be protected by the White House? Will there be transparency? Will there be access? And what is the role of the CDC in understanding the data? Now, I understand this is a question that we might not have enough time to respond to, but please, whatever you can shed regarding this wonderful question.
Yeah, I'm sure Jane will have something to say about this, but let me just say, I do think I told a very grim story that was all downside, but I do think there are lots of bright spots in today's world. And the fact that the CDC has their own Twitter feed is actually a good thing. And so if it makes it harder for the president, whoever he or she is, to be the sole source of authority on health information. But and that can be a problem, because you could have the government speaking at cross purposes. In fact, we've seen that several times in this COVID epidemic, right? And the governor is saying one thing, the mayor is saying another, and the CDC and the president are saying, things 3 and 4. But it's good that actually, if the president makes a power grab and tries to delegitimize or de-emphasize the CDC has plenty of platforms for conveying information to people who want to hear it. And I follow the CDC closely. In fact, you can follow a group of doctors in the Bay Area tweeting about COVID who might produce the very best evidence, the best analysis available, and they could be from private practice. They don't have to be government. That's, I think, one of the real upshots of the kind of messy information ecosystem that we live in today.
Wonderful.
Yeah, I would agree with that. There's not much uniformity of message, which is as its downsides during a pandemic when people ought to be coordinated. But there is still access to a lot of information. For one thing, each state's public health authority is doing at least some independent data collection.
Thank you. We're getting quite a few questions online through Q&A. So, and definitely lots of contact tracing questions, but this, I think this one is more of a commentary than perhaps a question. I think everybody agrees that we are way behind on contact tracing due to fears of interfering in privacy. Why not go old school and just hire enough of the unemployed to make phone calls to the contacts of people who have the virus? At least this way, the privacy problem is not as bad. Any comments?
So the privacy problem, so first of all, yes, we should also do that. There is some limit to what human contact tracers can do as compared to digital tech, and vice versa. They have sort of different opportunities and skill sets. Because a contact tracer, a human contact tracer, no matter how good they are, can't get a patient to remember some stranger that they saw in a grocery store, 5 days ago. There's also, though, an interesting, different type of privacy problem with human contact tracers that we're seeing emerge in the states that are actually bothering to do it. So you may have read it. There have been a few accounts of human contact tracers who just, first of all, can't get people to take their calls. If they do, the patients do not want to talk to a human about something that they did that they knew was risky. They went to an unnecessary social gathering. and it's embarrassing. And so there are some ways, there are the kind of nice thing, I guess, if you want to look at it that way, is that the privacy threats are different from, from faceless technology that can nevertheless use algorithms to more efficiently exploit us, versus humans that won't be able to exploit us as much, but just taps into our sort of psychological response more readily.
Thank you. Let's see. How is the link between racial discrimination and technology being addressed by U.S. technology experts and organizations?
That's a great question. And of course, we could spend an endless amount of time talking about it. It's so complicated because, of course, things like race, characteristics like race, correlate with other things like poverty, and it can be hard to disentangle what's the causal mechanism here. So, for example, just with COVID-19, there have been all these headlines that COVID-19 is disproportionately affecting different racial groups. And that's true, but it can be tricky to disentangle whether that is because those groups also tend to be less well off socioeconomically, or whether it's some racial characteristic. The tech, the tech world has real diversity problems, and that's not an easy problem to fix, because if the tech world is driven by computer engineering and it takes 10 years to become a good computer engineer, you can't just all of a sudden increase the diversity of the supply of computer engineers overnight. It's going to take a lot of aggressive recruiting and starting in elementary school and high school to get a more diverse engineering workforce, in my view. And just bouncing across topics here in this huge question of racial diversity and technology, is the one that I've been thinking the most about lately is I'm writing a paper about this, actually, is about algorithms and equality. There's a lot of concern about algorithms being racially unequal. And these are really legitimate concerns, fair concerns that I think were worth spending a lot of time talking about. But it is not at all obvious that that algorithms will necessarily be. So the dominant story is algorithms aren't perfect. They make mistakes, and they make mistakes in ways that affect one group more than another. The thing that you often don't see in those stories that drives me a little bit crazy is an acknowledgement that the alternative is sometimes much worse. So, for example, in bail determinations, there have been a bunch of news stories, some of which were nominated for Pulitzer Prizes, that identified that there are algorithms being used to determine who should get released on bail that have disparate impacts on different racial groups. And that's obviously troubling. We should worry about it. It turns out, though, those algorithms are less racially biased than the alternative, which is human judges. And we know that human judges are terribly racially biased. So I would just, when it comes to algorithms and racial justice, I tend to think, we can't let perfection be the enemy of the good. We have to address the problem. It's a very real problem. But if algorithms could in fact be perfected to be less racially biased than the alternative, which is judges who, by the way, we've been trying for a long time to be less racially biased, I'm not sure we should get rid of something that looks quite promising.
And I'd like to add that's a perfect example of how technology is actually just shocked the sort of scholars in a way that helps us understand what had already been occurring. So, I think one encouraging thing is that computer scientists, lawyers, technologists of every stripe are really focused right now on what it means for an algorithm to be biased, because it turns out that actually can define equity in a few different ways, and they're mutually exclusive. If you pick one, you're going to make another worse, at least potentially. But precisely because we've been focusing on it in the context of tech, we can appreciate that has always been true. And so the humans who were making decisions, even if they were responsibly pursuing one form of equity, a lot of times they're not doing very well on any form. But even if they were, it means that we've allowed each individual decision maker to set their own standard for what it means to be fair. And so this is a nice turning point, an opportunity to figure out what it is that we want to make sure is programmed.
Yeah. And when it comes to that marginalized recruiting, it could probably increase, not probably, but it would increase the numbers of Black and Brown technical engineers and so forth who are available but not hired. But that's not part of my role. So I'll get back to the questions. Why not replace tort liability for COVID-19 for businesses with regulatory fines for not following procedures? Would that not eliminate attempts to go for jackpot verdicts, which is what all of the businesses fear?
Yeah, so because I wasn't on the raised tort, I think that's another, maybe a better mechanism, is to have a regulatory fining system and some rules set out in advance so that everyone knows what the rules are.
What legislative or executive authority can restrict individuals from an otherwise legal business or employment activity?
Yes, I'm guessing that the nature of this question is about things like lockdowns, right? So one reason I got really interested in the privacy aspects of the COVID-19 response is that there was a lot of agitation at the beginning about a lot of fear about how the government would use surveillance data if they did wind up collecting data from, say, cell service providers or Apple and Google. But it seemed a little bit odd to me that that people tended to be quite nervous about that without also recognizing that we are essentially under house arrest right now. So if we think about the sort of 1984 style totalitarian dictatorship or system, we are the COVID-19 virus has pressed us into a set of really bad options and bad trade-offs. And so I think that at the time, at least, the decisions that were made to prevent people from going to work and socializing and whatnot made a lot of sense with the science that we had at the time. I think we're likely to continue to have to do sort of intermittent lockdowns in order to manage the public health crisis, and that is perfectly constitutional. There's been Supreme Court case law that allows things like forced vaccinations and forced closures of different institutions in order to manage a public health crisis. And so the real question is sort of whether the balance that's being struck is within a reasonable range. Andrew, did you want to?
I just want to add, I agree with all of that. And I don't think everything I've read, and I've been very curious about this, it suggests that the legal question of whether a lockdown is not actually, it's not a hard legal question. The authority exists for the government to mandate a lockdown to deal with something of, in the kind of scale that a pandemic presents. But I do think there is a very real public policy question that's not being debated intelligently. It's become politicized about whether, the precautionary principle, basically, better safe than sorry, about whether that is the right way to manage risk. So COVID it presents a risk, and it's a different kind of risk to every individual depending on pre-existing conditions and age. But our response to this risk has been to, in many parts of the country, to say it's too grave, and so we have to shut everything down. And there is very little discussion about all of the harms that come from the response. And I just think it's very serious. It's not at all clear to me that the response doesn't start to outweigh the risks that the original harm presented. And we're finally starting to have some of those conversations because people who have children are getting upset at the idea that their kids aren't going to be able to be in school in the fall. But the harms, began in March with the lockdowns. And we just never had a conversation, despite a lot of really compelling literature about the downsides to taking a kind of precautionary principle approach to risk. We never really had that conversation in this country. And again, I think it's one of those things where, maybe under a different presidency, it would have been easier to have a conversation about that without it becoming so political. It's worth noting, just one last thing, Daisy. This is a debate that people have in technology all of the time, right? With any new technology, there's a question about whether to be permissive and let it ride and just wait and see whether, what kinds of harms show up, or to take a precautionary principle approach and say, no, you have to prove that it's safe before we'll let you use it. And we adopt, the former approach with some things and the latter approach with others. And it's not a terribly coherent way to think about things. And I think that the more sensible approach would be to come up with some kind of test for deciding what kind of risks are presented by technology. And maybe with facial recognition technology, for example, you just think, look, there are so many exciting upsides that are actually quite welfare enhancing, and also some grave risks. And we think that on balance, the upside outweighs the downside. So we're going to allow it until we see that the downside really is too grave. But with self-driving cars, maybe the balance tips in the other favor, in the other direction. But we don't have anything like that at the moment. And I think it would be worth coming up with something like that.
Thank you. What are your thoughts on the proposed Earn It Act as it relates to COVID online security?
Yeah, so this is an act, Andrew, correct me if I'm wrong, the key or the most, the controversy around it is that it would strip online platforms like Facebook of its Section 230 immunity, which is currently the law that protects Facebook from being sued if some content that some user generated violates the law. So if I go on Facebook and I defame Andrew can sue me, but he can't sue Facebook. So this law would strip that immunity unless certain conditions are met. Andrew, maybe you could remind us what the conditions are. But the upshot is that there's a concern that by having to satisfy the conditions, there's going to have to be a lot more data collection.
Yeah, I think it will create that's my understanding of the law as well. I haven't followed it, to be perfectly honest. I haven't followed it as closely as I should. And that's partly because I assumed it was a non-starter. This is a pet project of a few senators that I think is designed to try to raise awareness. It's a way for lawmakers, without having to actually pass a law, to raise an issue that will rile up their base. And I think it's a really serious, important question, but I don't think the law has a chance of passing. And it's a way, without holding a hearing, of shining a spotlight on Facebook's and Twitter's practices.
If you don't mind, I think Facebook and Google are so widely sort of reviled and mistrusted that going after them is something that both Democrats and Republicans can do safely. And sometimes I think the reaction is completely justified, depending on what it is that the companies have done. But there is some risk that they have, may just become the go-to distracting device.
Yeah. Great. Do you feel the burden to trust each other in the rapid exchange of information online should be regulated by a system or a body?
Ooh, I want to take this one. Right up my alley. Yeah, so we talked a little bit about GDPR and the California law. What privacy law is starting to do is put choice in our hands. And that sounds great. We control our data. It's our property. It's a property rights conception of privacy. In practice, I don't think that it actually helps consumers much at all, because if you think I spend my most of my waking hours trying to understand what types of data uses wind up conferring benefits to the data subjects and which ones don't, which ones are harmful, and it's quite hard to do. If we expect each consumer to follow the likely drawbacks or benefits of data collection on their own and make an individual decision, it's too much to ask. It means that a lot of times they'll do whatever is the path of least resistance. They'll allow data collection, yes, click, let me get on to my game or whatever. And so it makes much more sense to me to have a public consensus built around what it means to have an information-based harm, and then have a regulator enforce that concept, make sure that any business that violates that concept of harm and risk, legally cognizable risk, is made to account for it.
Thank you.
But this position is not particularly popular with privacy advocacy firms, I should say.
Great. We have time for one more question, and we've just had some amazing questions. Last one. What do you think would be the ideal constitutional speech requirement for the digital age?
So here you might get two different answers, because Andrew's ready to reconceive of the First Amendment, it sounds like, to acknowledge that the problems of speech are different now that the largest threat and the mechanisms of production are different. So I'll let Andrew build that out in a minute, but I don't yet agree. I may come to agree with Andrew, see his point of view eventually, but right now what I see is, despite the fact that Facebook and Google and Instagram, all of the social media are big players, they to me look like they are slavishly pandering to the worst and basest instincts of the people who are on there socializing and talking to each other. And so it doesn't seem to me at all that this is some kind of I don't think there's enough evidence that there's a system of exploitation. Maybe at the margins, these companies have an incentive to make sure that people spend more time on Facebook. I'd agree with that. But to do that, they are basically giving us what we want. And what we want just is junk food, the junk food of speech, free speech. Having the government start to step in and manage that, to me, doesn't look like the right solution, because the government also is democratically accountable and therefore potentially accountable to our sort of, not necessarily our worst instincts, but the instincts that will change, as the winds turn. So that's why I ultimately, I see grave problems to our constitutional democracy because of the state of sort of epistemic development that we're in with Facebook and Google. And yet I don't see a viable solution yet. Andrew, thoughts?
Yeah, I have some thoughts. First, I want to say I saw who submitted that question. Ellie, that's not fair. That's an impossible question to answer in however many minutes we have left. But it's a great question. And, I just want to start the conversation about what this should look like. I mean, the thing that motivates me is, I share Jane's feeling that I'm not some huge fan of regulation. I'm not in favor of the government coming in and telling us how to live our lives at all. And a part of me thinks, well, Facebook is just a private company, and if you don't like it, don't use it, right? That's what in fact, I used to say that regularly. But we are slowly inching towards, maybe we'll inch away from this, but we are inching towards a world in which it is impossible to be a political candidate or to run a small business and not be on these platforms, okay? So if, in fact, all of the speech in the country happens on a handful of platforms from which users do not have a meaningful choice or alternative, which raises, of course, the antitrust questions. Maybe that's a way of resolving this. I don't know that it is, but they're related. If in fact, all speech in this country happens on private platforms, and that speech and the speech ecosystem is of enormous public consequence, I think the government should do something about it. So Jane says, that's what the people want. As long as they want it, it's fine. And I think, well, as long as they want it, it's fine until the republic falls apart. I don't want that. So I'm happy to say at some point it tips into an area of public concern, and the government should say something about it. The other thing is, we already live in a world where the government is heavily influencing Facebook to make certain kinds of censorship decisions, but the government isn't on the hook for those decisions. So the government regularly pressures tech companies to take down certain content or to change their algorithms. And that's a completely opaque process. It's been written about quite a bit, but that indirect censorship is really troubling. And we would be better off if the government actually said, here's the kind of information we want and don't want. And then we could have a debate about whether that's the right rule. But the system we have right now seems to me suboptimal.
Thank you. Well, thanks to everyone for your very thoughtful questions. And I wish we had time for more, but we don't. So at this time, we'd like our panelists to share any of their final thoughts. Why don't we start with Andrew?
Oh, okay. Well, I was going to just thank you so much, Daisy, for being our moderator, and thank everyone for the excellent questions. I don't have any parting thoughts. Stay safe.
Yeah, it's a good parting thought. I've said too much about contact tracing as it is.
Stay safe. We can let you off a few minutes early. Enjoy your
I think we can all say we had some outstanding panelists. And we thank you for attending this webinar and definitely for your active participation. A recording of the panel discussion will be available and sent to all attendees, as well as links to additional resources. So stay well and bear down.